Hello, and welcome to the first episode of the St Philip's Family Law Podcast. My name is Anthony Burgess, First Junior Clerk at St Philip's Chambers. But more importantly, today we will be hearing from three of our barristers, Susan Todd, Julie Mosley, and Emma Williamson, on the subject of evidence in cases involving the sexual abuse of children and ABE guidelines. The podcast will follow a question and answer format where we will be looking at key case law and the principles that can be drawn from those cases. You can find the notes from the podcast in the video description and on the website. And if you need our contact details, they are also in the notes and of course on our website. So without any further ado, I'll pass you across to the panel. Susan, thank you.
The key cases that we will consider are as follows. Re-T Children 2020, Re-B Allegation of Sexual Assault, Child's Evidence 2006, Re-J a Child 2014, Re-E a Child 2016, and AS and TH 2016. The significance of these cases is not that they establish new case law or new principles, but that they are very helpful in summarising and in some cases going in some considerable detail into the guidance that covers assessing and gathering evidence in sexual abuse cases. Before we turn to the case law, I'll consider the ABE guidelines, which are set out in Achieving Best Evidence in Criminal Proceedings, March 2011. That's the third and most recent edition. And those guidelines govern the questioning of children in sexual abuse cases. It's also essential to remember the Cleveland report, the report of the inquiry into child abuse in Cleveland, 1987, being the full title, which sets out what Mr. Justice McDonnell described in AS and TH as a plethora of salient and important guidance with respect to cases involving allegations of sexual abuse. The ABE guidelines incorporate many of the recommendations of the Cleveland report. I'm going to ask Emma and Julie what the case law tells us about how the ABE guidelines play out in practice. And key points that they will look at are as follows. First, how should a defective ABE interview affect the evidence and the judge's assessment in a sexual abuse case? Second, what if there is no ABE interview? Then there's the question about false allegations and the use of the term disclosures. Pretrial therapy for children in child sexual abuse cases will follow. So what do the ABE guidelines tell us? This summary is not going to cover every aspect of the ABE guidelines, but it will set out the most relevant points for our topic today. First, there's the importance of preparation and planning. The guidelines state at paragraph 2.1 that the importance of planning cannot be overstated. The success of an interview, and thus an investigation, could hinge on it. Even if the circumstances necessitate an early interview, an appropriate planning session that takes account of all the information is required. Second, there's the importance of the initial contact interview. The ABE guidelines state at paragraph 2.5 that any initial questioning should be intended to elicit a brief account of what is alleged to have taken place. A more detailed account should not be pursued at this stage. At the initial contact, the person speaking with the child should make a comprehensive note of the discussion, particularly the actual questions asked of the child and observations about the witness's demeanour. The child's own words should be used in the record that's made. Lastly, in the guidelines, there is the important section on how to conduct the interview itself. The interview should have 4 phases. Phase 1 is about establishing rapport with the child and talking with the child about the importance of telling the truth. Ground rules should also be covered with the child. For example, telling the child that if the interviewer asks a question the child doesn't understand, the child should say so. It should be made clear that the witness can ask for a break at any time. Phase 2 should comprise a free narrative account. Phase 3 involves questioning using open-ended questions in particular, and other appropriate forms of questioning where appropriate. Forced choice and leading questions should only be used as a last resort. Phase 4 is closing the interview. If appropriate, the interviewer should summarise what the child has said, and the interviewer must tell the child to correct them if something they have said is wrong. I'm going to hand over now to Emma and ask her some questions. Emma, what is the significance of the case of Re-T, April 2020?
Well, this was an appeal brought by a father against the decision of Coroner Judge Williscroft in Derby. The judge had made a number of findings of sexual abuse of the child known as X, aged 9, against the mother and also her partner, W. She also made findings of physical abuse and 2 findings of sexual abuse against the father. The findings of sexual abuse were firstly touching and digital penetration, and secondly attempting to engage X in intercourse. Father appealed those 2 findings of sexual abuse on the basis that, firstly, the evidence relied upon to make the findings is so flawed that it was wrong to place any reliance on it. Second, the judge was wrong to describe the allegations made by X in an interview as unprompted. And thirdly, the judge failed to adequately take into account the context in which the evidence found to be reliable was given, and the appeal was allowed.
What was the evidence that the judge had relied upon to make the findings, and why was it flawed?
Well, firstly, there was a family friend known as S who gave evidence that X had made allegations against her father. It was clear from the appeal that there were considerable issues with S's credibility. The next piece of evidence was a visit by a police officer to X on the 15th of October 2018. The evidence of that officer was that X had made allegations to the effect that her father had touched inside her genitals and attempted to engage her in intercourse. The difficulty, though, with that visit was that no proper record was kept of the discussion with X, and so the officer didn't seem to know when she gave her evidence who else was there or what questions she'd asked X. X was then AB interviewed on the 28th of October 2018 and again on the 5th of November. The first AB interview did not start with the usual truth and lies discussion, and X was not invited to say if she didn't understand. The interview was almost 2 hours long, and X asked more than once for something to eat because she was hungry. The intermediary intervened at one stage to indicate that X was struggling to maintain attention. During the interview, no alternative explanations were explored with X. For example, X had earlier referred to having had bad dreams about her father, but the police didn't check whether the allegations she made were dreams or reality. And the second AB interview started by simply prompting X as to the allegations she'd made in the previous interview.
Is a failure to comply with best practice and ABE guidance during interviews fatal?
No, the Court of Appeal was clear that failure to comply with the guidance will not always render the evidence obtained incapable of establishing acts of physical or sexual abuse. But there were, where there are significant and numerous deficiencies, as there were here, then that will clearly affect the weight to be attached to the evidence. A significant factor in the Re-T case was that the child had been subjected to considerable sexual abuse by her mother and by her mother's partner. The allegations she then made against her father were of a similar nature to the findings made against them. And it's very important, therefore, when considering flawed ABE interviews that don't comply with the guidance, to look to the external circumstances and facts of the case. It was made clear in Re-E 2016 that the judge must engage in an analysis of the process used to gather the evidence and allegations from the child or children so as to establish whether in all the circumstances it is reliable.
You said it will affect the weight to be attached to the evidence, but will a failure to comply with the guidelines not make the ABE interview inadmissible?
No, again, the Court of Appeal has been quite clear that there's no question of such evidence being inadmissible. It addressed the issue in Re B 2006 at paragraphs 40 to 42. And the Court of Appeal said that in a family case, evidence of this kind falls to be assessed, however unsatisfactory its origin. The focus, therefore, of the family court in cases where there have been failures to comply with the guidance will be on the value of the evidence and the weight to be attached to it, rather than on admissibility. A parallel can be drawn with the general approach to hearsay evidence in the family court.
What about in cases where there was no ABE interview at all?
Well, the President addressed this question in Re J 2014 at paragraphs 73 to 75. In that case, there was a vulnerable adult known as X who had made allegations against a child's father when she was herself 17 years old. There had been no ABE interview. That does not, however, rule out consideration of the other evidence about what a complainant has said or done. For example, here there was evidence of what she'd said to various professionals when she was 17, and also her oral evidence to the court during the proceedings. The court should, however, be careful to consider the impact of the lack of ABE interview. The fact that the judge in this case had not expressly mentioned its absence or brought that absence into her evaluation was held to be a significant omission.
Thank you very much, Emma. I'm going to turn to Julie now and ask her about the case of AS and TH to begin with. Julie, what is the significance of the case of AS and TH?
Well, this is a 2016 case decided by Mr. Justice MacDonald. He was determining allegations made by a mother against the father of one of her two children. The allegations were that he'd physically and sexually abused both the children and herself. And the father was also facing criminal charges in respect of the same allegations, with a trial date set later in the year. After a lengthy hearing, the court found none of the allegations were substantiated. And at the conclusion of the hearing, the father then invited the court, on the basis of the evidence, to make a number of different findings, namely that each of the allegations of the mother and the children were false, that the children had been each coached or influenced by the mother into making the allegations, that the mother had told lies to a series of professionals, and that a number of professionals had acted in breach of their professional duty by failing properly to investigate the allegations, and that in consequence the children had suffered significant emotional harm. And Mr. Justice MacDonald did make each of those findings. And so the case is significant, not because it creates any new interpretation of the law. This case gives us a good general overview of the clear case law and guidance which Mr. Justice MacDonald finds is still ignored by professionals, and he reminds us the damaging consequences for children. His judgment starts by referring in fact to much older cases, Ray E in 1991 and the Leeds matter in 2008. And in those cases, the judges were already expressing concern that despite the passage of time since the Cleveland report in 1987, the witnesses had not read it, or if they had, they'd ignored the conclusions. And Mr. Justice MacDonald, within this case, was asking whether the lessons of the Cleveland inquiry had been fully learnt. I think the resounding conclusion is no. For example, he notes, and I'm quoting now, despite the fact that the use of the term disclosure to describe a statement or allegation of abuse made by a child has been deprecated since the Cleveland report due to it precluding the notion that abuse might not have occurred, every professional who gave evidence in this case, except the children's guardian, used the term disclosure to describe what the children had said to them. So my view is the significance, therefore, is that it's a clear restatement and reminder of how sexual abuse allegations should be conducted by professional agencies and police, the impact of the failure to follow the guidance, and how the court will assess the evidence in respect of allegations. and it draws together and sets out the clear guidance available for professionals in cases of investigating sexual abuse, which comes from case law, the Cleveland Report, ABE guidance, and some government guidance, which is the Keeping Children Safe in Education and what to do if you're worried about a child is abused.
What does the case say about how sexual abuse investigations should be conducted by professional agencies?
Well, Mr. Justice MacDonald is setting out again the need for clear and scrupulous regard as to the guidelines by all the different professionals involved with the family and the effect of the breaches. And the effect of the breaches is both on the court's approach to considering what weight the evidence can carry, but also stressing that it can lead to emotional harm in itself to the child from professionals if the investigation is not open-minded, planned and thorough. And the stages he considers in this case go back to what you've already talked about, Susan, the initial contact with the child, the need for proper recording, not just from social workers and police, but also, for example, teachers, and not just what the child has said, but the context of them saying it. And then that initial social work assessment, stressing that initial action in securing the widest possible information about a child's circumstances and family background is what he says an essential prerequisite to careful judgment and purposeful intervention. The concern that he raises is, again from the Cleveland Report, that in investigating this, social workers should be conscious both of the presumption that abuse has taken place, which can have damaging repercussions for the child and the family, and balancing also an abnormally low level of alertness to the possibility of child sexual abuse, which could deter children from then trusting adults to be able to reveal abuse. And also he considers in this case the deficits of a police interview.
What does the case say about false allegations?
That care must be taken not to focus attention on statements made by the child at the expense of other evidence, particularly where allegations of abuse arise in the context of private law disputes, as he found here was a motivation for the mother. And within the best practice guidance of June 1997, he quotes, an investigation which focuses attention on the statements of the child runs the risk of producing a false result if what the child says is unreliable, or if the child's primary caretaker is unreliable, particularly where the allegation emerges in bitterly contested Section 8 proceedings. And it reminds us, because he quotes from the Ray W. case 2014, that conduct at this level by a parent should be understood to equate itself to serious child abuse, and that will usually necessitate intervention by a court. I think also it's probably important to remind ourselves the failure of professionals don't lead then to an automatic consequence that the court finds positively that the child has been coached or manipulated, but rather what Mr. Justice MacDonald describes was that the repeated and persistent poor practice by a range of professionals in this case aided the mother to succeed in enclosing the narrative she had created within what he describes as a hermetically sealed bubble. And thereby, she succeeded in preventing professionals carrying out checks that would have revealed that the allegations that were being made first by mother and then the children required at the very least a critical and questioning appraisal. And because the professionals had adopted an almost entirely unquestioning approach, they themselves agreed to their confinement within this bubble. And had they adhered to well-established guidance and procedure, they would have discovered that the allegations simply lacked credibility.
What does Mr. Justice MacDonald say in this case about the court's approach to assessing sexual abuse allegations?
He reminds us that the court should adopt a two-stage process. First, is there evidence of sexual abuse? If so, is there evidence of the identity of the perpetrator? He reminds us that the court will consider all the relevant evidence of the case. There was a broad canvas of available relevant evidence concerning the child's family background, relationships, pattern of family life, social development, and involvement with other agencies prior to the making of the allegations. He sets out the consequences of the breaches in the approach to evidence. If a joint child abuse interview conducted by police and social services doesn't follow the memorandum of good practice, not only does this affect the forensic value of the interview, but it may impede or contaminate then any further assessment of the child ordered by the court. And in his judgment, he found where, as in this case, there'd been a failure to follow the interviewing guidance, the court is not compelled to disregard altogether the evidence obtained in the interview, but may rely on it together with other independent material to form a conclusion. However, where the court finds that no evidential weight can be attached to the interviews, the court may only come to a conclusion that relies on the contents of those interviews where it has comprehensively reviewed all the other evidence. And of course, he stresses the consequences of the breaches of the children because he was satisfied that the actions of certain professionals in that case actively contributed to the difficulties that he sets out in the case and materially prejudiced the welfare of both children. And so in this case, he found that almost all the professionals and agencies had adopted from the outset an unquestioning basis that mother was telling the truth and had failed therefore to interrogate that by basic inquiries, that a number of professionals failed in their duty to keep accurate records, that there was a failure to limit the amount of questioning outside the ABE interview, that agencies had failed to coordinate their interventions, that there were significant breaches within the police interview, and that also by the time before fact findings and any criminal trial, there'd been extensive therapy and CAMS intervention with both children on the basis that both children had been abused in the manner alleged by mother.
Leading on from that last point, could you tell us about the guidance that exists in relation to pretrial therapy in sexual abuse cases?
Yes, that was considered, and it's signposted within the ABE guidance. The guidance is, the title of it is Provision of Therapy for Child Witnesses Prior to a Criminal Trial, Practical Guidance, brackets CPS and the Department of Health with the Home Office 2001. Because in some cases, separate pre-trial therapy or counselling work will be necessary to meet the needs of the child. And what the guidance says is that once the video recorded interview is complete, it should be possible for appropriate counselling and therapy to take place. It should become standard practice to inform the police and the CPS about the nature and the content of the therapy in each case. And the defence may justifiably wish to know about both the nature and the content of the therapy that's taken place before the child gives evidence in cross-examination.
How does this guidance about therapy bear upon us as family practitioners?
Well, I would suggest the two most common situations. If during care proceedings there's a view that a child who is likely to be a witness in a family or a criminal trial is considered to need therapy, then we need to be aware and make sure everybody else is aware of the very clear guidance available before decisions are made and therapy commences, because of the risks that therapy could contaminate the evidence by, for example, the process of repeated discussion, or that the evidence is compromised by that suggestion being open. A decision should be made in communication with police and CPS, And if the therapy goes ahead, the therapist also needs to be fully familiar with the guidance. And for example, self-esteem work could be done, fully recorded, and avoid discussion around the actual allegation. The second way I think that we need to be aware of it is if we're dealing with fact-finding issues, there is a clear importance of establishing what therapy, if ever any, that there's been, when it was in relation to any allegation or any interview or recording of evidence, the content of the therapy, were the allegations talked about, was it conducted on the basis of them being an established fact, what recording of that was there, and then we have to then consider the interplay of all of this with the allegations themselves and ensure that the court considers that too. Thank
you very much, Julie. You've been listening to Susan Todd, Emma Williamson and Julie Mosley, and we hope you found this podcast on evidence in sexual abuse cases and ABE evidence helpful.
Thank you for joining us on the first St Philip's Family Law Group podcast. We hope you've enjoyed and found it useful, and we hope that you will listen or view our next podcast, which will be coming along in a few weeks' time. Please stay tuned to our website, our social media platforms, particularly Twitter and LinkedIn, for more information, and we hope to speak to you again soon. Thank you.